Good evening, distinguished dignitaries, our guests from abroad, delegates, professionals, gracious ladies and gentlemen. It's a profound pleasure to be present in this august gathering, a hall filled with architects of our collective future, lawmakers, business leaders, academicians. Decision you make now will have lasting effect over decades to come. We meet today at a crucial inflection point in human history. As we speak, geopolitical tensions are simmering, economics are being stressed by their breaking points, markets are on a free fall, resulting in a commercial uncertainty and disputes. But perhaps most significantly, there is an increasing sentiment of institutional fatigue, a growing sense that our traditional mechanisms of justice are perhaps struggling to keep pace with velocity of modern conflict. We are witnessing a paradigm shift where the old command and control concept of law is being tested by a globalized world that moves much faster than a court calendar. In these circumstances, can we afford a stick to adversarial dispute resolution instead of embracing the era of problem solving? First, I will say evolution of disputes resolution. As we embark upon a discussion about dispute resolution and the future of law and the role of courts, arbitration, mediation, and technological advancement shaping the future of justice system globally, in order to understand dispute resolution, we must first define the problem. What exactly constitutes a dispute? Every dispute begins with a gap between the expectation and reality, a perceived injury. In the foundational wisdom of Indian scripture, we find Sanskrit principle that Satyena Rakshet Dharma. Truth protects the law or the Dharma protects the truth. The Supreme Court of India, the most consequential apex court in the world, guardian of the aspirations of the largest democracy over 1.4 billion people, has adopted a similar principle in its motto, reminding us that victory is not the trump of might, but inevitable crowning of Dharma. It is motto is yato dharmas tato jaya. Where there is a dharma, there is a victory. Truth is the tool which sustains dharma, and the path of dharma is what leads to jaya. The ultimate victory, which is no longer just about winning a case, it is restoration of balance. Dharma is alignment of reality with justice. Then a dispute is the fracture of that alignment. When the truth of one party no longer aligns with the truth of another, a claim is made and it is rejected, is when dispute is born. Now, here the role of courts come. In the journey of the adversarial to problem solving, however, the courts will continue to stand as ultimate guardian of rights and the rule of law. But they can no longer be viewed as the only source of justice. Development of multimodal dispute resolution system is perhaps the best decision we can take for our progeny and for future. This evolution of justice from litigation to resolution requires a concerted effort from all of us by approaching the understanding of courts as an essential service instead of physical location. Professor Frank Sander, Harvard Law School, way back in 1976 proposed what he called a multi-door courthouse model.